Commonwealth versus Webb.
Now, Mr. Gagney, I guess it's you, although my wonderful law clerk has told me it was Mr. Cohan. So everybody agrees you're going first?
That was our understanding.
Fine. Good morning, Mr. Gagney.
Good morning, Your Honors. May it please the Court, Stephen Gagney for the Commonwealth. I'd like to start by, on behalf of the Commonwealth, thanking the panel for accepting this case for further appellate review, because in the Commonwealth's view, the Appeals Court did not take a realistic view of the evidence in this case, did not truly look at the evidence pursuant to the Lattimore standard. When this Court first touched upon some of these issues in Commonwealth versus Wall, this Court stressed the importance of taking a realistic view of the situation and also considering whether a scheme in actual operation is a lottery. Shortly thereafter in Hefner, this Court stated that whether or not a particular scheme constitutes a lottery depends upon the particular facts and circumstances of each case. Here we have not your typical sweepstakes or promotional device where typically a person making a purchase, which they may ordinarily do in their normal course, passively receives an item or a chance to win. Here we have calling card dispensing machines placed specifically in bars and restaurants where the playing of this gambling device, this overtly casino-style gambling device, is inextricably interwoven with the actual purchase itself. Essentially, the defendant in this case combined what was an otherwise legitimate business transaction, and the Commonwealth does not contest that these were legitimate calling cards, with a gambling scheme. And the mere coupling of the two does not make the gambling suddenly legal.
Well, the thing that causes me a problem is, if I understand the facts, a person could play for free all night long if they were willing to fill out a card from time to time. Is that so?
It was claimed there was a free play element to this.
Well,
yes.
That's
not just a claim.
You say it was claimed. Wasn't that also a fact, that if you filled out the card, you got the free play?
That is what the defendant's corporate attorney testified to, that there was this feature, and it was advertised on machines that there was a free play option. However, there were several aspects of that free play option which, in the Commonwealth's view, rendered this illusory. First of all, starting with the premise as stated in Wall, that just because some people play for free doesn't mean that those who are paying to play aren't engaging in a lottery. Secondly, there was no evidence in this case that people were actually employing the free play option. Detective Govin, in his undercover capacity, never saw any such cards displayed, never saw any cards being used.
He never asked for one, did he?
He didn't ask for one, no, but when conducting the search...
It wasn't like he went in and had these places under observation. He went into play. I think he went into four different places or 3 different places and saw one person playing at each place.
Yes, but...
This is determinative?
Well, the significance of that in the Commonwealth's view, when you view that in the light most favorable to the Commonwealth, is that Sergeant Govin was essentially conducting spot checks of these establishments. He only did go in 2, 3, maybe 4 times between Blondie's and LePage's, but every time he went in, he himself was either able to engage in this gambling or he observed other patrons doing it.
Is there a plausible connection between the value of the calling card and the amount the buyer was paying for it? I mean, are those...
Well, that's another feature which I would say differentiates this from a normal sweepstakes. Here there was a direct proportional relationship between how much somebody paid and how many gambling credits they received. Rather than receiving one chance per transaction, regardless of the size of the transaction, here the ability to gamble and the number of credits you could play with was directly proportional to the amount the player paid.
Unless they filled out a card.
More cards.
Well, first of all, as this court noted, Your Honor, in Commonwealth versus Freight, well, there wasn't much discussion of it in that case, but there was a no purchase necessary free play option available in Freight. Nevertheless, this court still held that a violation of Section 7 occurred.
Yeah, but you had to send it away and wait for the mail to get there? I mean, it was quite different as a factual matter, wasn't it?
It did make it slightly more, it would be more burdensome, yes, but still, there was the ability for people to play for free, and that didn't defeat the scheme.
Well,
And-
isn't it your burden to prove, or is it your burden to prove that unlimited free play was illusory?
Yes.
And how did you prove that? You saw 3 people play for money. The officer played for money. Never asked for a free play card. So how did you prove this beyond a reasonable doubt?
The facts the Commonwealth would point to, and viewing them in the light most favorable and drawing reasonable inferences, are as follows. First of all, although it was an option for players, it was not the exclusive means by which these machines were played. It was one option. People could also pay to play. Secondly, no evidence that these cards were actually used or seen in any establishments. Third,
No.
You have to help me there. I mean, you've got sort of random testing, so
every time, it's
Yeah,
the
yeah.
Commonwealth's contention that these spot checks, these undercover operations conducted by Sergeant Govan, at no time did he ever see anyone else using the cards. He never observed the cards in plain view, and when the search warrants were conducted at the 2 establishments, no cards were seen or seized.
But there were signs on the machines, weren't there, that said, words to the effect of, if you fill out the cards, you get free play?
Yes. Yes, that was made known, but the cards themselves that were actually introduced by the defense at trial, the suspect and inaccurate contents of those cards, in the Commonwealth's view, lends further credence to this scheme being illusory, that these free play request cards were just an attempt to circumvent the law, as opposed to offering free plays.
I thought you said that you agreed that the fact that there was some mistakes in those, that that they weren't totally factually accurate wasn't critical to the illusory argument. Is that not so?
If I did, I misspoke. No,
I probably misunderstood it. I'm
it's the
sorry.
Commonwealth's view that when you look at those cards, and whether or not those cards were of any value to the defendant, where particularly people were listing inaccurate addresses, people who claimed to have never filled them out, one person who listed a bar as his or her residence, you look at the suspect contents of those cards, and when you view that in the light most favorable, which the appeals court did not do, it further suggests that this whole free play aspect was illusory.
Were any of those people called as witnesses?
They were not called as witnesses, but Detective Govan was allowed to testify that he had spoken with several of those persons who denied ever having been in either of those bars or filled out the free play request
No
cards.
objection to that testimony?
It came in. It did come in.
Did Detective Govan ever ask for a free play card himself and was denied one?
No, he did not. No,
shouldn't he have? Or had somebody else ask for one?
he could have, but even if these free play request cards were actually used, even if he had used one, it's still the Commonwealth's contention that
What's the consequences of using a free play card or a purchase card to the player?
if the player filled out a free play request card, he or she received a dollar's
plays.
worth of play,
5
which I
plays,
think was
right.
5 credits, so about
Yeah.
20 cents per credit. So
Right.
you sit down, you fill out this form, your name, your address, your
Yeah.
telephone number, you get 5 credits, $1 worth on the machine. And a player could play that, and theoretically, if they were unsuccessful, they wanted to play more, go back, fill out another form, get another 5 credits worth, and you could theoretically
Pay to play.
or
You
you
got to buy
drop
the ticket. You got to buy the telephone cards.
or you drop down a $20 bill, and not only the number of credits goes up, but as the appeals court noted, the odds, the chances, the number of credits with which to play, and inferentially the ability to win cash prizes increased.
What's the benefit to the owner of the establishment from having this?
Presumably,
Inducing
draws people.
gamblers to come and...
a
Draws
bar or
people.
restaurant, if it's known that you can go there and play these machines and gamble and win perhaps $20, $50, $100 or gift certificates, it would increase the establishment's,
Mr. Gagnon,
Wait, I haven't got the answer. It would increase the establishment's what?
it would increase their business.
You mean
There was no
someone
evidence that it
would
happened.
eat and drink while they were there? Is that the
Or
point
buy
of it?
things.
It could.
Buy
I
things.
suppose that would be the benefit to the bars, to the restaurants, that their own revenue would increase.
Have them? or are they illegal?
For entertainment purposes, if a person wants to play to accumulate more credits so that their play is lengthened, that's fine. That's not illegal. That's an amusement device.
Not in this Commonwealth.
You may have a you may have a privilege, Your Honor.
I've seen these things are being used, so these people are doing these without license?
Well, it's no secret that sweepstakes, that perhaps video poker machines are prevalent. But the fact remains that just because it may be prevalent, there may be sweepstakes, video poker machines. That doesn't mean, yes. If there's cash payout,
If the city wanted to bother with it, they could bust it.
if there's anything of value being paid out to a person playing this game of chance, that is illegal.
What if you go into McDonald's and they're having a promotion? Okay, you buy your hamburger and french fries, and they give you something to scratch, and if you scratch it, you get your money back. Legal, illegal?
That I would qualify as more of a sweepstakes, and there are distinguishing features between that scenario and this one. First of all,
No, there are, but is it legal or illegal, in your opinion?
That's for us to say.
well, if you take
A lot of this goes on, you know.
yes, and if you look
Yeah.
at Section 7, the wording of the statute states that even under the pretext of a sale of a legitimate product, if there is a lottery being conducted as an additional inducement to the sale of that item.
That's why over the radio you
This goes
hear
on-
all of the time, you don't have to buy a thing, you can do it for, it excludes all the employees, and by the way, you don't have to pay a thing, you don't have to give a contribution, you can just send us your name and address and we'll put
This
you
is a
in.
different point. Isn't your point a different point? Even if you do all of that, it might still run afoul?
It may.
Is that what you're saying?
It may, but it does, but and significantly, all of those promotions seem to end with, as the signs atop the machines here did, void where prohibited by law. So it is the language of the statute that controls. No,
Not McDonald's.
and this, Your Honor, would take me back to the principle expressed in Hefner that each case must be judged by its particular facts and circumstances.
Could I
And here-
ask you about the facts in this case?
Yes.
If, as I understood, as you were answering a question of Justice Cowan or Justice Bartlett, I think, you said if you pay to play, it may be easier, you know, because you can get more time, but also your odds increase.
No.
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 No, not necessarily the odds. If I said odds, I misspoke, but
Okay.
the accumulation of credits. The larger the number of credits a player has, the more they can play, the more credits they can wager at a particular time. Essentially,
I see.
the stakes go higher.
So it just means you have to take the time to fill out, if it's $10 worth, you've got to take the time to fill out 10 cards.
Yes.
Rather than put a $10 bill in and get a $10 telephone credit, plus get $10 worth of credits.
And even as this...
Play credits.
And even
So
as
this
the,
thing that Jordan's Furniture did about getting your furniture free if the Red Sox...
I did notice some discussion about whether that was on the line, near the line.
Anybody who has any problem
you
with the
think?
Red
Is it over
Sox
the
winning
line?
the World Series is not going to get very
Is it
far.
over the line? I mean, he apparently had to shell out close to $1 million, which an insurance company was, paid.
Well, I'd suggest that this particular case has distinguishing circumstances, which...
Not
if this-
answering my question. What about office pools on the basketball tournament, the collegiate
Well,
basketball tournament?
I myself noticed the Patriots are 20.5-point favorite tonight. This happens.
Gambling with the...
This
with
does
the
happen,
NFL.
and it's, again, it's not a...
But in your office, though.
Again, not in the Bristol County District Attorney's Office.
think so.
But again, the point is that even if this is prevalent in different shapes and forms, in this particular case where you have gambling machines with overt
Can of soup getting 2 free at the supermarket.
buy one, get one,
Get 2 free.
that's just a business setting its
Price.
price for a product.
Okay.
But here you have machines with overt gambling characteristics, components. You have player participation where they're deciding how many credits to play on a particular case, which cards to keep, when to spin the wheel. This is a permanent and integral part of the defendant's scheme. This was not a one-time, limited duration promotional affair. These components were built into the machine from the start.
Mr. Gagné, if I may interrupt you, could you just say, if you take a look at the decision of the appeals court, where do you say the appeals court went wrong? I mean, I've read your brief, but I've also read the appeals court's decision.
I would have 4 points, Your Honor. Specifically, well, 3 of them to the Lattimore standard. First, where it noted that the Commonwealth's suggestion that the free play option was illusory is without evidence to support it. When you view the evidence in the light most favorable to the Commonwealth, first, the fact that the cards were never seen, no cards were ever seized,
Right.
and the suspect contents of the cards that were introduced, that suggests a jury could find, a fact finder could find, that cast doubt onto the legitimacy of the free play option. 2, the court stated we place no significance on the inaccurate contents of the free play request cards. Well, the issue here is the free play option a reality or a sham? And that's the language from Wall. And when you have these cards, if I may
If you may
complete
finish.
my answer.
Sure.
When you see these cards where people list their a bar as a residence, Fall River addresses with Swansea zip codes, that tends to suggest it's a sham. And that is where a fact finder or a jury could conclude that this was illegal. Third, the court stated in footnote 10 that the burden or the disadvantage to a player who wrote out the free play request card, that the court stated it was, quote, obvious that there was some burden and some inconvenience to a person who had to do that. But then the court went on to say, but it wasn't so great as to be a disadvantage. Well, the case law to date hasn't said that it must be a great disadvantage or a great burden,
Okay.
but rather that if there is some burden attendant to that.
And your last?
Lastly, when the court cited, and I believe footnote, well, perhaps the last footnote, Commonwealth versus Freight,
Okay.
trying to distinguish Freight, the court said that the game and the sale of the product were wholly separate, that the game stood separate. To the contrary, in Freight, the defendant established this CompuPick machine where a person paid a quarter, the machine generated a random number for use in the state lottery, and also at the same time provided a chance to win. So Freight, I suggest the court misinterpreted the facts of Freight in trying to distinguish the free play option.
Thank you, Mr. Gagney.
Thank you, Your Honors.
Mr. Cohan?
Thank you. May it please the Court, Dana Curhan for Stan Webb. With me is Attorney Brad Benyon. I think there are 2 issues in this case. I mean, the first issue is whether the lottery statute was violated, and the second is whether the defendant committed any criminal acts, assuming it was. And as to the first issue, I think the Mobil Oil held that the price element was not satisfied if there was a meaningful opportunity to play for free, and if players who play for free were not placed at a disadvantage. A player who filled out and received 5 game credits was at no disadvantage to a player who paid $1 and received 5 game credits. A player who filled out 20 of these game cards, free play cards, and played was at no disadvantage to a player who paid $20.
So is the time it takes to fill out the card is not a disadvantage, in other words?
No, I don't think so. If he had to mail it in as in freight and put in a self-addressed stamped envelope and wait a couple of weeks for his free play, that's a problem. I think that would be an illusory free play. But if all you had to do was ask for a card and fill it out, I think that's not a significant disadvantage. It may be a little bit of an inconvenience, but once you fill out those cards, you are in exactly the same position you'd be had you bought.
So the misstep by the officer was not asking at these establishments if he could have a card.
Absolutely.
And being told, we don't have them, that's a come on, or anything, or we don't have them.
I think that's correct. And he didn't ask for them, and he didn't look for them. They executed.
But I want to ask you that question. You say you didn't look for them, but there was a search warrant. What was the testimony about what was searched for and what was discovered, or was there testimony in that sense?
I don't think there was a lot of testimony. There was. They seized the machines. Yeah. I'm not sure if they understood the significance of these free play cards at the time they executed the search warrant.
The search warrant's not in here, so I don't really know what's in the search warrant. But did the officer testify about seizing the machines?
He did.
Was he cross-examined? Did you search for free play cards? I mean, was there any kind of questioning about that?
I'm not sure if that question was asked.
Out of curiosity, what was the sentence here?
The sentence was, I think it was just a fine.
Yeah,
And it's not a question of, I mean, the real issue here is not the money. The real issue here is
Can this continue?
there's a criminal conviction right now. And I think, the Commonwealth raised the question of whether these calling cards were available. I mean, and raised the question based on the fact that the cards that were provided by the attorney a lot of them had phony names or addresses. I mean, I think if you're in a bar and filling out a card for a free play on a machine, I'd suggest that very few people would give their actual name and address. I think you...
Because they don't want to be bothered with it.
That's right.
With a solicitation later on the telephone or somewhere else.
Sure.
Mail, whatever, saying, well, by the way, you had a free play, now we want to talk to you a little bit more about this product.
Absolutely.
You may not want members
But
of
is
your
that the
family
evidence
to know
most
where you've
favorable to
been.
the Commonwealth?
That's right. I'm sorry?
Is that really looking at the evidence most favorably to the Commonwealth?
Well, I think the... I think I would agree.
In fact, there was evidence of free play.
There was evidence of free play.
And that was the filled-out cards?
That there were some filled-out cards. But I don't think... I agree with the appeals court. I don't think those cards were particularly significant.
Why?
I mean, the information on them.
The information on them.
No, but the fact that the information was false may not be... The fact that they were free cards is certainly significant.
You know,
Well, the fact that there were free cards, yes, I think that is significant.
but
The game had this free element to it.
what
Yes.
the appeals court was talking about the contents, that it wasn't
That's right.
significant that the information might not be accurate.
The content I don't think is legally significant. There were signs on these machines telling people about the availability of unlimited free play. And I think it was incumbent on the Commonwealth to actually attempt to do a free play.
Well, he agrees with that. He said he's got to show that the free play option was illusory, and he claims that he did. The
Well,
Commonwealth
In
claims
the
that he
light
did.
most favorable to the Commonwealth, don't you get to a jury?
I don't think you do, because I think
Does?
the Commonwealth has the burden of disproving free play, and I don't think they did that. I don't think they offered any evidence on the point. Now, assuming we have a violation of the statute, the question is what do we do with Mr. Webb? There's a gaping hole in the Commonwealth's proof here, in that they put his lawyer on to say, well, we assume that he put them in the bars, but we don't know what the discussion was. They prosecuted everybody, including the bartenders, and did not do what is typically done in these cases where they go to a bartender and said, look, can you come and testify? There's no evidence as to what the conversation was between Mr. Webb and what, if any, conversation there was between Mr. Webb and the bar owners. If Mr. Webb went in and said, look, here's how we do this. Here's a stack of free play cards. You put these behind the bar. There's a sign on the machine. If anybody asks, you give them the card, you give them the free play. That conversation never, there's no evidence of that. There were no witnesses.
He testified?
He did not testify.
Did the appeals court didn't discuss the point you're making now, did it?
They did not.
Was it argued to the appeals court?
It was certainly argued to the appeals court. And I think they didn't reach it because they didn't have to. They answered the first question, that there's no violation of the statute. And the second question, even if the Commonwealth proves its case, they have not proven Mr. Webb's involvement. If he said, look, here's how to do it legally, here's how to do it correctly, and the bar owner said, we don't care about these free plays, go toss these in the trash.
Did you say that the bartenders were also prosecuted for this?
My understanding is the bartenders were.
But it wasn't one trial, it was separate trial?
I think there were separate trials. Mr. Gagnon can probably tell you better than I can, but they were not tried together with Mr. Webb. But usually somebody approaches somebody and says, let's make a deal here. The Club Caravan case, that issue was raised in a sort of tangential way where there was testimony as to an arrangement between the distributor of the machine and the bar owners. And I think it was the appeals court said that that is enough to survive a McCarthy motion, but expressed serious doubts as to whether it could survive proof beyond a reasonable doubt.
So you're arguing that there was no evidence of Mr. Webb's participation in these machines being put in, even though he was a distributor?
Well, he may have arranged to put them in. His lawyer said, well, we assume that we'll concede that he made the arrangements and he put them in. But there's no discussion about what the precise arrangement was.
Why does that matter?
Why does that? Because if he arranged to have these machines put in and set it up in a way that was legal, that did not violate the statute, and then the bartenders then disregarded his instructions and used them in a manner that was inconsistent with
If
the
he
way...
said, like, bartenders were supposed to say, you know you can do this for free and here are the cards. If
That's
he had
right.
told them that and they just didn't follow that. And
That's right. Here's a sign on the machines. Here's a stack of cards. This is what you do.
But all
And
the
this is
evidence
le-
was that that was what was being done.
Well, no, the evidence was that that was not what was being done. Well, actually,
There was
There was
no
actually
evidence.
no evidence on the
there was
question.
no evidence one way or another. I mean, the Commonwealth took the position that wasn't being done and that the statute wasn't being followed.
your point is that if one could find, even if one could find on the evidence that the free play option was illusory in the freight
That's right.
context, there still isn't enough to convict your client because we don't know whether he was the one who made it illusory or whether that was the bartender's reinterpretation of his instructions.
That's right. And he did go through the trouble of vetting this through his corporate attorney.
Yes,
But
can
that
I
was
ask you
true in
that? I
freight
wanted to
as
ask you
well.
about the significance of that. His corporate attorney testified.
Yes, he did.
And I take it testified that he or some other attorney had opined that setting it up this way complied with state law.
That's right.
Is that significant to us?
It's significant in that, well, I think it's significant in that the opinion was correct. If you set it up the way it was supposed to have worked, the way he said to set it up, I think that would be legal.
Yeah, because that's the Commonwealth is saying it's illusory. If it's not illusory, in other words, if they're free plays and if I walk in and just as long as I'm prepared to sign to fill out a card, I'm not even required to fill it out and show my driver's license to make sure it's me. I just have to fill out the card.
That's
correct?
right.
And if I'm prepared to do that over and over again, fine. I don't think the Commonwealth is saying that makes it a violation of the lottery statute. What the Commonwealth is arguing is that the access to free cards was in fact illusory, correct? So it's perfectly consistent to say, my lawyer gave me my good advice, and that it may not be an intention, it may not be probative for intent or anything like that, but it's just to say, I try to figure out how to do this legally, and you're saying, and then who knows who made it illusory?
Absolutely.
Okay.
Because if Mr. Webb had the cards printed out and gave it to the bar owners with instructions, this is how you do it, put the sign on the
If
front of the
anybody
machine,
asks, give them one of these, and if they fill it out,
give them a free play.
I can't understand why this case even got this far. I mean, if this was such a big problem, Commonwealth go to the company, Mr. Webb, whatever it is, and say, oh, look, in our opinion, you're running an illegal lottery here. Take the machines out. But I guess we don't know anything about what discussions took place before.
Well, I think there was some evidence that from his lawyer that he called, I believe, the Attorney General's office and maybe the DA's office.
Yeah.
And nobody was really interested in talking to him about it. I mean, he did make...
This is when it was being set up.
When it was being set up. And I know when I was in the DA's office, all the calls ended up in the appellate division, and we got 20 of them a day about the open meeting law and the violations of this, and a nice little old lady who had some kind of raise that came out of her faucet, and everything else. And
Category?
I think that may have fallen in this category where calls were made and nobody picked up on it. And so-
Was there any evidence or was there any argument by the prosecutor that these free play cards that had been filled out had not been filled out by people who actually played for free, but in fact were just a response to the criminal charge?
I don't think there was a lot of discussion about this.
How many free play cards were introduced?
I do not recall. I don't think there were that many, and I think the Commonwealth's position was that we don't even know which establishments these were from. I don't think they took the position that the lawyer had forged them or that Mr. Webb had forged them. I think they just took the position that these are not legitimate cards and therefore... total in all the bars?
Yeah.
I mean, I'm not sure.
But could a jury have concluded that those cards, those free play cards, were indeed trumped up?
I'm not sure. I don't think so. I really, there was no evidence one way or another. And the fact that the police officer testified that these people were not, did claim to be not in the bar that night, or that the addresses were incorrect, I don't think there's any legal significance to that.
But
Still,
can
it's
I ask you this
equally-
question? Can I mean, how do these cards get into evidence? I take it, were these cards somehow turned over to the prosecutor's office just to sort of demonstrate that in
I think-
fact some cards were used? Or?
I think that the lawyer did turn them over to the prosecution. I don't remember which side
Okay.
actually introduced them.
But the lawyer didn't come in and say, you know, here, I've gone through our corporate files, here are all the free cards that we received, and lays out 6 free cards with names that turn out not to be real. Is that the context of this, or is it something different than that?
I'm not sure.
Mr. Cohan, any problem with the Julian selections?
This was jury waived.
Oh, Julie waived, of course it was.
What was the purpose of even keeping the cards? Why not throw them away the same day you get them? Is there some consequence for not recording or not reporting to some governmental agency that certain games were played for free?
I don't think so. I think probably the purpose of holding onto the cards is that maybe something of value. If you have 2,000 cards with people who play these buy phone cards and video machines in bars,
You can sell
somebody
them.
may be willing to pay for that.
Which is why a lot of people put down.
Exactly. Don't want the junk mail. Unless there are any further questions, I will submit the remaining points
Thank
in
you,
the
Mr.
brief.
Cohan.
Thank you.